Welcome to this presentation on the medical and legal aspects of marijuana and cannabinoids. I am Dr. Sandbar, a physician and an attorney. Cannabinoids are neurotransmitters. Neurotransmitters are the body's chemical messengers which are used by the nervous system to transmit messages between nerve cells called neurons or from neurons to muscles. Endocannabinoids are synthesized endogenously in neurons. The two best studied endocannabinoids are anandamide and 2-AG, which is the abbreviation for 2-arachidonyl glycerol. Phytocannabinoids are synthesized exogenously in cannabis plants. There are over 100 compounds of different types of phytocannabinoids, but the two best known are THC, which is delta-9 tetrahydrocannabinol, the psychogenic compound, and CBD, which is cannabidiol, the non-psychogenic compound. This presentation deals mainly with exogenous plant phytocannabinoids. They are found in the plant family called Cannabaceae. The plants are called Cannabis sativa, Cannabis indica, and Cannabis ruderalis. There are four main categories of phytocannabinoids. The first is religious, sacramental, or spiritual entheogens. The second, industrial hemp or industrial cannabis. The third, medicinal cannabis. And fourth is recreational cannabis. Entheogens induce a spiritual experience that is aimed at sacred use. They have been used by indigenous peoples for thousands of years, and many books have been published about them. Entheogens are all psychoactive substances. They include cocaine, ephedrine, ecstasy, peyote, LSD, psilocybin mushroom, and marijuana or THC. Here are pictures of the three types of cannabis plants: Cannabis sativa, indica, and ruderalis. Only the Cannabis sativa strain with a low psychedelic THC content is suited for industrial hemp. Marijuana with high THC content is derived from other strains of Cannabis sativa and from indica and ruderalis. Industrial hemp is extremely important to farmers. Many products are derived from hemp. Let me give you some examples. Hemp rope is famous, and it is used for many purposes. Hemp is used to make frames for sunglasses and goggles. The hemp fiber is used to make paper, fiber, sheets, shoes, all types of clothing, and jewelry. Hemp is used to make composites for cars, such as dashboards. Hemp is nutritious. It is used to make different foods as well as oil for cooking. It is even used for building materials. And it is used in nanomaterials such as graphene-like nanosheets used for supercapacitor electrodes. Hemp is used for soil remediation and reclamation. Hemp is also used in many cosmetic products. and it is used in 3D printing filaments, bioplastics, and many other products. Now let's turn to medical and recreational marijuana, and I would like to summarize federal cannabis law. During the past 114 years, cannabis federal law has made a full circle, which will be discussed in the next few slides. Every date that you see on this slide will be covered. Please keep in mind that before 1906, cannabis use was legal in the United States. In 1906, Congress passed the Pure Food and Drug Act, which prevented the manufacture, sale, or interstate commerce of deleterious foods, drugs, and medicines and liquors. The act included opioids and marijuana. In 1913, California was the first state to prohibit the sale and possession of marijuana because it was perceived as a killer drug, a powerful narcotic in which lurked murder, insanity, and death. The following year, in 1914, the Harrison Narcotics Tax Act was passed. It controlled the possession and sale of narcotics, especially cocaine, opiates, and marijuana. Interestingly, in 1925, the U.S. Supreme Court decided the case of Linder versus United States, in which an Oklahoma physician gave Ida Casey 1 tablet of morphine and 3 tablets of cocaine for her addiction. She took the drugs alone in divided doses over a period of time to satisfy her cravings. The trial court ruled that the treating physician violated the Harrison Narcotics law. But the U.S. Supreme Court reversed, and it held that the direct control of medical practice in the states is obviously beyond the power of Congress. In 1919, the 18th Amendment to the U.S. Constitution passed. It established the prohibition of alcohol and intoxicating liquors, but marijuana was not included. In 1933, the first major farm bill, called the Agriculture Adjustment Act, was signed by President Franklin D. Roosevelt during the Great Depression. That same year, 1933, the 21st Amendment to the U.S. Constitution repealed the 18th Amendment that ended the nationwide prohibition on alcohol. So, what happened? The focus turned to marijuana. 4 years later, in 1937, Congress passed the Marijuana Tax Act. Doctors could prescribe marijuana for medical purposes, but had to register and pay prohibitive taxes. Consequently, prescribing marijuana was curtailed. In 1962, the case of Robinson versus California was the first landmark decision of the U.S. Supreme Court in which the 8th Amendment of the U.S. Constitution, which deals with cruel and unusual punishment, was interpreted to prohibit criminalization of particular acts or conduct as contrasted with prohibiting the use of a particular form of punishment for a crime. At issue in Robinson was a California statute that made narcotic addiction a punishable misdemeanor offense. The U.S. Supreme Court ruled that California could not imprison a person solely for being addicted to narcotics. Thus, in general, a law that punishes a status like addiction will not be upheld. On the other hand, a law that criminalizes behavior against the public interest is likely to be upheld. In the 1960s, Dr. Timothy Leary was a clinical professor of psychology at Harvard University. He was a prolific author and was known for experimenting with psychedelic drugs under controlled conditions. He was arrested at the Texas-Mexico border for possession of marijuana, which was in violation of the Marijuana Tax Act. He was sentenced to 30 years in prison. In 1969, on appeal, the U.S. Supreme Court held in Leary v. U.S. that certain provisions of the Marijuana Tax Act and other narcotics legislation were unconstitutional. A year later, in 1970, President Richard Nixon declared a war on drugs and signed DAPCA, the Comprehensive Drug Abuse Prevention and Control Act. Title II of DAPCA is the Controlled Substances Act, CSA, and THC and CBD were placed on Schedule I. In 1973, the DEA, Drug Enforcement Agency, was established to implement regulations pertaining to the Controlled Substances Act. In 1999, the U.S. Supreme Court decided the case of Bob Randall, who had glaucoma that could not be treated with medications or surgery. To alleviate his eye symptoms, he grew his own marijuana plants and began smoking it. He was arrested with possession of marijuana, a Schedule I controlled substance. Medical experts stated that the inhalation of marijuana was actually beneficial to his glaucoma, and defendant Randall asserted a necessity defense to his prosecution. The issue before the U.S. Supreme Court was whether Randall is barred from asserting the necessity defense. The Supreme Court held that he was not barred from asserting the necessity defense to his charge of possession of marijuana. In December 2018, a new farm bill called the Agriculture Improvement Act became law. It descheduled hemp products from the Controlled Substances Act. Hemp was defined as cannabis and its derivatives with very low concentrations of THC, no more than 0.3% on a dry weight basis. Thus, CBD was no longer a controlled substance. And that brings us to November 19, 2019, when the Marijuana Opportunity Reinvestment and Expungement Act, or the MORE Act for short, that cleared the Congressional House Judiciary Committee. If enacted, the MORE Act would remove criminal penalties for marijuana. It will take the drug off the federal controlled substances list, and it would expunge conviction records. But 6 days later, on November 25, 2019, the FDA noted that despite removing hemp From the definition of marijuana in the Controlled Substances Act, CBD products are still subject to the same laws and requirements as FDA-regulated products that contain any other substance. So, federal cannabis law has indeed made a full circle. Well, what about cannabis state law? In 1996, California was the first state to allow for the medical use of marijuana under the Compassionate Use Act. As of 2019, a total of 33 states and the District of Columbia, Guam, and Puerto Rico have approved a comprehensive public medical marijuana cannabis program. 12 states allow recreational use of marijuana, and 13 states allow the use of low THC, high cannabidiol, which is CBD, products for medical reasons in limited situations or as a legal defense. Only 4 states have no public cannabis access program. Presently, THC is still a Schedule I drug. It is viewed as unsafe and ineffective. But is THC unsafe and ineffective for any indication? The answer is no. In fact, the FDA has approved several cannabinoids during the past 2 decades, including Epidiolex, Marinol, Sandros, and Sesamet. The FDA must have established that these synthetic cannabinoid drugs were sufficiently safe and effective to approve them. Epidiolex is indicated for 2 severe seizure disorders, Lennox-Gastaut syndrome and Dravet syndrome. Thank you.